alleged, after they alleged the same set of facts, the false facts, the malicious facts, but they were all the same. And I want to say that on behalf of my client, we want to express gratitude to the staff in this case. She's been falsely accused of doing things she has not done. She's been singled out in that regard. And there's a real consequence in that community to that. So we are grateful to your investigators for arriving, doing the hard work. We're grateful to Miss Naomi for the work she's done, because I know the record that she had to look through. I disagree with what they're recommending because of the background that I just gave you, fully mindful that the easy answer is to follow your staff. But the problem that we have here is that in doing that, you're supporting people who made false and malicious claims. That's our allegation. It is now established through the evidence by the recommended order that Judge Patterson signed. So I also want to let you know how grateful we are to your other staff, to Millie Fulford, and to your general counsel. They've just been so helpful in this process. If you were ever accused of doing things by 4 people, that provides credence to the allegations. Mr. Toe here filed a claim that was unmerited, unwarranted, and unsupported by the evidence the first time. When he lost, he came back, he filed yet another, and got 3 people to come with him. They literally testified that they got together and wrote out the complaint, and there were claims that were not proven. They were just not true. The judge saw that. He knew that. So you had a really good judge in this case. I'm wondering if he didn't break it out because of that fact. They were all saying the same thing. And ultimately, the goal here is to stop the false complaints, the false statements about my client. It didn't stop the first time around, so we felt we had to use this tool in the toolbox that the legislature handed us with the hope that the false allegations, the malicious allegations, the meritless allegations against my client will stop by these 4 people. Mr. Toe is provided an attorney through his insurance policy. So he hasn't suffered any attorney's fee loss in this case. Mr. Bailey is represented by Mr. Heron, but he wasn't at the hearing. I was at the hearing with the judge where the evidence was taken. So you probably, you have a tough choice here. Our ultimate goal is to clear the name of this innocent woman, and secondarily, to get an enforceable order. And overreaching all of that is to stop the malicious, false claim, lead to the expenditure of taxpayer dollar. And she's not the only one who's been the recipient of this, but she is the only one who has been brought before you twice. So I appreciate your attention.
Commissioner, is there any questions from the commission? I have a few. Procedurally posture here today, we are here purely on a determination of motion for attorney's fees, correct?
Right, it's a petition for attorney's fees.
And we've already determined the merits of, we were given a sizable record to review before this hearing today, and I speak on behalf of my fellow commissioners, we reviewed everything from the initial complaints through the entire process. So we have a substantial background to today. My concern here is this is the procedural posture of attorney's fees. The row is well established. As someone who's an expert witness on attorney's fees, I know that that needs to be provided. And in my home court of the Middle District of Florida, it's not uncommon to consolidate the cases. Then after obtaining a ruling, referring back to the magistrate judge to determine attorney's fees in those individual cases, not on a joint and several liability basis, but individually. Why would this one be different than that scenario?
I think that's a great question. I too practice in the Middle District of Florida and mostly in federal court. This is indeed a very unusual case. It doesn't fit into this fact pattern of other cases that I've read. There are really only two cases that guided me in prosecuting this, and the case that was the most helpful was the Al-Hadid case. And actually, Mark Herod represented my good friend Al-Hadid, who was a county attorney in Flagler County. In that case, Mr. Hadid, there were separate claims against Mr. Hadid. The evidence wasn't that the parties got together and wrote out the complaint as we have here. So it's a Hobson's choice kind of case. Our case does not fit in. It's a case of first impression, in my opinion. Doesn't fit in with any other logical case that we've had, because it's unusual to have four people conspire to invent facts that are not true. So I think the judge can give it a try if you send it back to him. If I were to pick, I would say Mr. 2 is the most culpable. He was the leader of the pack. But I'm concerned about, let's say he does divide it up 4 ways. Aren't we setting ourselves up for more criticism there when they all sign the same set of facts? It's a really difficult call, to be candid.
I appreciate it. Any other questions from the commissioners? Thank you. We appreciate your time. Ms. Naomi?